that a witness is not telling the truth will be in the eyes. And that's why I am adamant in training cross-examiners. You will not take your eyes off the witness. You will not have any notes at the podium. If there's something in writing you need to look at, reach back to the defense table and look at it, but keep your eyes on the witness, period. That's it. Also applies to jurors when you're arguing and judges. And the essence of good cross-examination for lawyers well prepared is the speed with which it's administered. The speed is a very important element, simply because even experienced witnesses should not be given time to think up their answers as you go along. They should be not pummeled, but questioned very rapidly, and that means not spending much time looking at your notes.
Were you present when he arrived from Chicago and they slapped handcuffs on him?
Yes.
Oh, well, yes. Well, when you slap handcuffs on someone, you're taking him into custody, aren't you?
Not always, no.
Oh, you have the right to handcuff a citizen without a criminal charge?
There are instances you could, yes.
Have you done that in the past? Handcuff people against whom there was no charge?
Oh, well, there's times when people pick people out as suspects and you later identify that they were not the suspect and you would release them.
But that wasn't the case here, was it?
I don't know what the case as far as he was handcuffed.
Did you really have any business at all in inspecting those bodies that morning?
Yes, sir.
All right, and where in the manual is it mandated that you do that?
I have no idea.
It isn't mandated in the manual anywhere, is it, Sergeant?
I don't know.
When was the last time you read the manual, do you remember?
Cover to cover? About 15 years ago.
And any part thereof?
Probably 3 to 4 times a week.
Okay. Are you therefore saying that you have not used that word in the past 10 years, Detective Furman?
Yes, that's what I'm saying.
And you say on your oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman?
That's what I'm saying, sir.
So that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman?
Yes, they would.
All of them, correct?
All of them.
All right, thank you.
A favorite and legitimate tactic is to pin them down on cross in a way that they know you can go out and get the answer if it's different than the one they've given. That's very intimidating. When you say, well, now, is it your claim that you spoke with Mary Smith at 9 o'clock that night? Yes, and this is the same Mary Smith that lives at so-and-so and has his phone number. Yes. And do you know when she was last interviewed? Guy begins to think, my God, have you been out talking to Mary and what's she saying and so forth? And at that point, you can probably see the witness falter. Or if it's an experienced liar, you'll never see a change in the features, but you hustle right out to say Mary Smith. I have done a lot of remedial investigation in the midst of a trial, probably in more trials than not, that either saved the day or changed the course of the trial, simply because there were areas we didn't know about. Didn't know there were opportunities out there until people began to talk, and these are people who would not talk to us before the trial. In states where you cannot take their depositions, and even if you can, because good deposition taking is very different than handling a witness in a courtroom. If you know what you're doing, the information might not have come out. In other words, you don't like to spend all of your cross-examination currency in a deposition and educate the other side. You want to learn information, not give any out. In cross-examination, you necessarily give it out to let the witness know which corner he's being put in and the point at which it might be a good idea for him to capitulate. I spoke highly of Judge Charles Rosansky if a witness were sufficiently cornered so it was perfectly plain that he or she was lying. The judge would momentarily take over the cross-examination and say, reflect on your answer. The jail is near at hand. And oh boy, did those witnesses start remembering at that point. I mean, good investigation, you keep all your cards close to the vest instead of feeding information to people who may use it to alter their stories to try and fit the evidence. And that's a technique because there really are no law schools that have a good course in investigation that I have ever run across, and I have lectured at well over 100 of them. And lawyers who did not do investigation before they graduated law school and took the bar just don't have a lot of experience or instruction along this line. Now, the former police, some insurance adjusters, they can be pretty good. I am reminded of my first year in law school because we got a midterm examination in contracts, which fascinated me, and I studied it very hard. And I got a 96, and the next highest grade was a 72. And the professor, who also practiced law and ultimately became the dean, stopped me on the street corner shortly after the exam, and he said, "I want to tell you, I'm glad you were in my class." And I said, "Well, I'm enjoying your class. This is a great topic." He said, "Well, all that being true," he said, "you're the only proof I have that the message was delivered." That kind of has an analogy to the Simpson case in this respect. At the end of the trial, one reporter, the only really qualified reporter with lots of credentials and lots of experience, Linda Deutsch, wrote an article showing why O.J. couldn't have done it and was properly acquitted. There is nothing more delightful, if you're on the right side of the fence, than watching a well-prepared case flower, and nothing much more frightening if it's flowering against you, because there's nowhere to go. I waited till about 10 minutes of 4 on a Friday, knowing full well that jurors take the most recent developments in a case home for the weekend. And I asked her in about 6 ways if she had in fact deliberately refused her husband medical treatment. And then I asked her whether or not Dr. Coppolino had ever recommended he get medical treatment. And she denied it all unequivocally. So I showed her only that part of the document which had her signature and not the rest. And I asked her, "Is this your signature?" She looked at it and said, "Yes." Then I opened up the document. I said, "Will you tell the jury what it is that you've signed?" "Well," she said, "that's my signature, but I have no idea how it got there." And from then on, she was in big trouble, and the case was out the window.